Mr. Sanford, you may proceed.
Thank you. Good morning, Your Honor. May it please the Court, I am Bruce Sanford of Baker and Hostetler, counsel of the newspaper and its veteran reporter, David Wedge. Your Honors, I apologize for my voice this morning. A wintry blast has infiltrated my sinuses, I fear. At the heart of every libel case, Your Honors, whether it involves press reporting or not, are words, the choice of words. And this case is certainly about Judge Murphy's use of language and the newspaper's news reports about how prosecutors and crime victims objected to his choice of words.
Mr. Sanford, does it make a difference for our purposes whether somebody is a public official or a public figure?
I think not, Chief Justice. I think for your purposes, the test, the burden of proof for a public official and a public figure under the New York Times doctrine is essentially the same. That is, they have to prove with clear and convincing evidence that a false statement of fact that defamed the plaintiff was published with actual malice. And so it doesn't make much difference.
Well, there was plenty of evidence to show it was false, was there not?
I think
for the jury to find in the light most favorable to the plaintiff, which, of course, as you know, being an experienced lawyer, is the standard under which we have to view this.
Right. Justice Graney, I think there is, at the most, tepid and inconclusive evidence of falsity on this record. And I would ask this Court, under the Bose decision and under your McAvoy decision, which was decided shortly after Bose, and since that time the highest courts of states around the country have interpreted Bose to mean that you really have to substitute your judgments for the inferences and the weighing of evidence that a jury may have found in order to ensure that a verdict does not intrude upon the field of free expression.
Well, yes or no. We weren't there. We can't assess credibility as the jury could. So that standard you just articulated has to be tempered a bit. We're not a second jury.
I agree with that. You're not a second jury. But I do think the Bose case, in libel litigation, Your Honor, insists that appellate judges do a searching, de novo, independent, there's that word, independent review, to be sure that credibility, even credibility determinations, can be weighed to be sure that the plaintiff has met his burden. It's just a very unusual appellate standard in libel cases, and I think it is different than in most appellate
Mr. Sanford,
cases.
let me go back to my initial question and just press you a little. I understand that, starting from the sort of what the classic standard is, but when you look at how Bose has been actually applied in cases, have you discerned any pattern as to what the courts have done with respect to jury libel damage awards with respect to public officials versus public figures?
Yes, I think you'll find that, and I think the statistics bear this out, it's cited in our brief, that about 70% of public official libel verdicts are reversed on appeal as unsupported by evidence.
And
so
if you look at the public officials, does it make a difference as to what kind of public official it is? I would suggest that it does to this extent, Your Honor. I think when a sitting judge comes into a courtroom that the standard is a little bit different, a little bit higher for him than, say, a member of the executive branch or the legislative branch of government. And that's just being real world. I think when a sitting judge comes into a court and asks in libel litigation, I think fortunately or unfortunately for him, public perceptions of confidence in the judiciary are at stake. So how he or she handles himself in that libel litigation is terribly important, not just to his claim, as in this case, but to really the public's perception of justice and the fairness of justice.
Mr. Sanford, did Mr. Wedge ever interview David Frank?
David Frank was, of course, Your Honor, the prosecutor in the McSweeney case, and I'll have to check the record.
But he was the one, apparently, to whom this was supposedly said.
No, that's
to
not.
him. But the individual assistant district attorney to whom Mr. Wedge did speak apparently made the statement first to Mr. Frank, so that he made it when it was freshest in his mind.
Yeah, and I think
Mr.
it was
Frank,
error for the
supposedly.
trial judge not to permit Prosecutor Frank to testify to that. The sequence of events is the comment that the judge made is made to Prosecutor Crowley,
And Crowley
not in
then
the
says it to
McSweeney
Frank.
case, not in the McSweeney
I
case,
understand that.
but in the Burgess case. And then in a break in that hearing, Prosecutor Crowley goes out and he sees Prosecutor Frank in the hall and he says, "You won't believe what I just heard."
Yes, but you're changing the effect of my question.
Right.
I'm not asking whether the judge let Frank testify. I'm asking whether your reporter ever tried to interview Frank, which would have been...
I don't know that he was relevant to the question of what the judge said
Well,
to
Crowley reported it to Frank when it was freshest in Crowley's mind.
Right, and
So
then he
I
goes
would think
back.
it would be relevant, but your reporter never saw it.
Well, I'll have to double check that,
it's
Your
not-
Honor,
it
in the
doesn't-
record and stuff. I'm not sure that the
And
record
don't
is
you
clear
then
on that.
minimize the importance of the two words, tell her? Because it's one thing, it's a wholly different, it puts a wholly different spin on the statement if it's tell her to get over it, or if it's, if the statement was made in the context of the judge's efforts to get assistance. I've got to help this woman, she's got to have counseling, she's got to get over it. I mean, you don't, you minimize the addition of those two words, tell her.
Let me say this about tell her. I would say that those are immaterial, insignificant words, but more importantly than what I feel,
Why
the
are they
prosecutors,
immaterial?
the prosecutors didn't feel that that was important two words at the beginning of the quote. And indeed, Fitzgerald, the prosecutor Fitzgerald, does testify that he heard Crowley say that, and he told David Wedge this. So there is a basis for reporting that, okay? But I think the actual malice law could not be clearer that we do not ask reporters and sources to agree precisely on every single word of a conversation.
Well, that may
in
be,
libel
but
litigation.
when there are words that change the gist of the whole statement, tell her is a very harsh, would show a harsh-feeling person. Tell this poor rape victim that she must get over it is very different from saying she's got to get over it, I'm going to get her assistance, she's got to do this and that. It puts a whole different spin on the statement.
And Crowley himself testified, didn't he, that when he saw the quote, tell her in the newspaper article, he was taken aback by it. He was saying, that's not what I told the reporter.
Yeah, but Your Honor, there is inconsistency in the record about that, because
Yeah, but the
Fitzgerald
jury-
says he
But
did
the jury
tell
could
the
find-
jury,
The
and he told...
The jury can sort that out and accept the fact, which they obviously did, that Crowley did not make that statement to Wedge.
But
And then I think you've got deep trouble here.
Well, I cannot agree with that, Your Honor, because I think the words teller in the nobody felt, none of the prosecutors felt that teller made any difference, whether
Mr.
it's
Sanford,
you
Crowley
should get
did.
over it.
Crowley
or
thought it was
He
significant.
didn't call, no, Your Honor, he did not call the paper and say the quote's inaccurate. Nobody ever called. Nobody ever made tell her anything of importance in this case until the litigation started.
Mr. Sanford,
Teller is not significant. The operative, objectionable word is get over it in reference to a 14-year-old rape victim. Not
But
tell
get,
her,
but
or
get
she's
takes
got
on a
to,
different
or...
context depending on what precedes it. If it's tell her to get over it, it's very different from she should or she must get over it in the context of some counseling and help for her.
I
Changes the
think,
whole
Your Honor,
sentence.
with all due respect, I think you're parsing that sentence far too much. The
Mr.
operative,
Sanford,
objectionable
Mr.
word
Sanford,
is get over it.
Mr. Sanford, let me try it this way. It seems to me that what the prosecutors were complaining of or criticizing Judge Murphy was a bias, and then it's either in favor of defendants or against victims. And to the extent that a statement exacerbates an indication of bias, it may be beyond parsing. And the reason why I asked you about public officials and whether it makes a difference, it seems to me that from a judge's perspective, probably the two most serious charges that one could make against a judge are, one, corruption, and two, bias, persistent bias or bias in a particular case.
Not being fair. Yeah, I think
Well, being fair.
Right, not being fair or having
That's a flip side of being,
predisposition.
of being
Although I
biased.
would say the interesting thing about this case, in the journalism of this case, I think three things, Your Honor, is that it is not an investigative piece. The Boston Herald was the 8th newspaper to report this story. Okay, when I was a reporter at the Wall Street Journal before I went to law school, we used to call these roundup stories because they take a series of multiple incidences in multiple counties in eastern Massachusetts and put them all together for a regional newspaper in Boston. And if you look at the first article, that's exactly what it does. It rounds up multiple complaints from multiple prosecutors in multiple counties about Judge Murphy. The Get Over comment is only the most recent example of it,
Did
but
you
there are many
introduce,
others.
were those other articles introduced in evidence?
Some were, Your Honor, and some certainly can be taken, and all of them can be taken judicial notice of.
Let me explain again the thrust of my argument. I have looked to see in which circumstances jury libel damage awards have been upheld on appeal when those libel awards have been entered against judges. I haven't done the galactic search. But one of the most recent ones was the Texas case where the claim there was corruption. Now, Texas is a little different because the judges run for election. But again, it struck me in reading those opinions that it's not as if this is a libel claim that has something to do with the judge's private life, although the code of conduct, of course, applies on it. But this goes to the heart of what the judge is most concerned about, or should be most concerned about.
Well, and I think it goes to the core, in terms of the journalism, it goes to the core of what the Sullivan doctrine protects in journalism, and that is public criticism of public officials. That's what it's all about. And here we have a classic controversy between two branches of government, the executive branch, the prosecutors, unhappy with the judge. The public obviously needs to know that when it raises to a certain decibel level, as it did in this case. But the common ground for deciding this, however you feel about Judge Murphy's burden of proving substantial falsity, however you feel about that, the common ground is actual malice and the lack of any evidence of actual malice in the part
Well,
of the
let me ask you one question, and that has to do with the destruction of the reporter's notes. Apparently he was on notice that the judge disagreed with the accuracy of the article almost immediately, within a day or two of it being published, and yet he destroyed his notes. And he couldn't indicate how long he had kept them or what his normal practice was. Couldn't that be used to infer actual malice?
I think there are a number of cases, Your Honor, excuse me, where that is not evidence of actual malice. I direct your attention to the Peeler case in South Carolina is one case. There are many others and stuff. What the record does show here is that David Wedge disposes of his notes regularly, routinely, and he did that here.
But he was
This
on
is not a
notice here.
destruction of evidence
Here
issue.
he heard from the lawyer for the judge within a day or two of the article being published. So to destroy the notes when he was aware that the judge disputed that seems to me to suggest an intention to destroy evidence.
And also, the
Right. Well,
plaintiff's
can I
brief,
just-
the plaintiff's brief at least indicates that Wedge could not testify that this was his normal practice, that he fudged on that, and he couldn't. At least that's the plaintiff's brief.
What he said in his deposition, Your Honor, was he couldn't tell exactly when he disposed of them, but he just disposes of notes when he doesn't need them anymore, which is what most reporters do. If I can go back now, the Owen Todd testimony at trial was very startling, okay, and it was disputed by David Wedge. David Wedge says very clearly at trial that Owen Todd did not tell him, as Judge Murphy's lawyer, that
Of
the
course,
judge denied it.
the jury heard both
Yes.
the reporter
Todd's testimony,
and
Your Honor.
Owen Todd, and
Yes.
the jury could decide who they would believe.
Yes, and you have
That's the credibility call.
You have to weigh that evidence, and I would say that If Owen Todd had said that, it would have been in the Boston Herald. If Owen Todd had said it to the Boston Globe, and there were 2 occasions and 2 articles in the Boston Globe in which Owen Todd was quoted, but it carried no denial. The first time Owen Todd says anything about Judge Murphy denying this is at trial. Okay? And there's plenty of pretrial evidence where Judge Murphy himself says the first time he denied it was on March 6th. There was no reason whatsoever why Judge Murphy could not have denied it if he didn't make the statement when David Wedge sought him out not once but twice to get a comment. It would not have been a violation of the judicial canons of ethics. There was nothing to stop him from saying, I didn't make that statement. Prosecutors sometimes don't like my opinions. That's why we have judges.
Mr.
There's
Sanford,
nothing for him
Mr.
to stop
Sanford,
saying that.
Could you remind me of the chronology after the first newsprint publication of the Tell Her to Get Over It, and what happened between that and then the interview with Mr. Wedge on national television? Had anybody in that period of time told either Mr. Wedge, the Boston Herald, the publisher, the news editor, whatever the chain of command was, that the statement was false?
Not that the statement was false. All there was in the March 6th article in the Boston Globe, 3 weeks after.
No, I'm asking whether anybody had told Mr. Wedge, the Boston Herald, any representative of the Boston Herald.
No, Your Honor. There was just an article in the Boston Globe on March 6th, and then after that, Mr.
And you're
Wedge,
saying that the article on March 6th did or did not say it was false?
It did not say it was false. It just carried Judge Murphy's denial for the first time. And actual malice law, again, is clear that this is all, if this is all this is about is him denying the statement, you have a prosecutor on one side saying he said it. You have 2 prosecutors, long-time reliable sources, who said he told us he said it. Okay, on actual malice law, it is clear, it seems to me, under your King case here in Massachusetts, under the precedent of 40 years since
New York Times
versus Connor, really, which is the case that is most instructive to your deliberation, the case out of Birmingham, Alabama in 1966, a seminal case 2 years after Sullivan, that is very close. It's the closest analog to this case because it's based, the reporter's statement is based upon an alleged quotation that he gets from a reverend about what Bull Connor says. And it's almost a direct analog. And in that case, clearly there was not clear and convincing evidence of actual malice.
In our independent review under JNOV, what do you say we are obligated to do with respect to the inference of the destruction of notes? Do we pay heed to the inference that arises from Owen Todd's testimony, or do we consider the inference that arises from Mr. Wedge's testimony on that issue?
2 points, Your Honor. I think if you look at all the cases since Bose, Wayne Newton versus NBC, Tavlares versus the Washington Post, and appellate courts in your position, what they do is they say, we have to substitute our judgment for the inferences and the weighing of evidence. I agree with Justice Graney about the credibility determinations, maybe something else. You really have to see if there's sufficient weight there. But I think here what's important about the notes is that I never have understood what is supposed to have been in those notes that could be damaging to David Wedge's case. The reason there's no actual malice here is David Wedge.
The words tell her might be in there or might not be in there. The words
but
tell
there's
her
nothing
might
you
be.
can even conceive of, Justice Cohen, that could have been in those notes. What we have here is 3 prosecutors telling him that Judge Murphy made the statement. He goes to Judge Murphy to do. He does everything that your King case says he should do as a reporter.
He didn't call David Frank. He didn't call David Frank.
But David Frank wasn't a party to the test.
He was the first one to have heard Crowley say that.
And if the judge had permitted him to testify, he would have said, Crowley did tell me that.
Mr. Sanford, could I ask you a question about Mr. Frank? At the time that Mr. Wedge was doing the follow-up, did he know that the first person that Mr. Crowley had spoken to was Mr. Frank?
I'd have to check the record on that again, Your Honor.
That
I'm not
was not
sure
my
that he did know that.
That was not my understanding.
No,
my
I don't think that
understanding
he
was
did
he
know that.
went to the speaker, he went to the judge, he went to the prosecutor.
Right.
I mean, I don't know whether he knew about Mr. Frank.
No, I think my colleague, Mr. Brown, tells me the answer is no.
That was my understanding.
Mr. Frank, he might have found out about him. Mr. Frank is an incidental player in this, although he is interesting that he was the first person that Crowley told, and if he had been permitted to testify, he would have said that about that. What David Wedge did was there isn't anything, in my view, Your Honor, that he could have done further in this case that would have materially have changed this article.
What about the victim witness statement? Do you admit that that was incorrect? That when the paper said that the victim tearfully stated blah, blah, blah?
Yes.
So you would admit
that is a mistake. It's, I would say, a
right.
technical mistake because it says that she took the stand.
But that's such an objective. If he had asked anybody, he would have found that out. And the second one was when he said that that there were prosecutors, plural, present at the conference when there was only one.
Yes.
And that's another.
Yes. Well, that is, in a figurative sense, it's true because all the prosecutors were confronting Judge Murphy publicly about this.
In different conferences, but not
you're right.
at
It is
that
a technical.
conference.
It is a technical mistake to have a plural there.
It gives the whole article then has a flavor of inaccuracies.
I cannot agree with that, Your Honor, and I don't think, with all due respect, that appellate judges are charged in libel cases to be superannuated editors of cases. That's not what the New York Times versus Sullivan case in Bose asks you to do. It asks you to see whether there is clear and convincing evidence of actual malice in a case. And if you look at all of the precedent, including your own precedent, in the King case, you will see that what David Wedge did in this case, what he did was what any professional reporter, he tried his level best and better to get it right. And I would submit to you this morning that there is nothing else he could have done that would have materially have changed that article. You may not like the article. I can certainly understand that. But that is, and there may be a couple of technical mistakes in it, but that's not either substantial falsity, and it's certainly not evidence, clear and convincing evidence of actual malice.
Well, how can
Thank
you
you,
say
Mr.
the victim tearfully took the stand when she didn't even testify? Isn't that some clear evidence that he didn't state the facts?
That is a
correctly?
mistake. I would say that it is an immaterial mistake to this libel litigation, which is about whether the judge said about a 14-year-old rape victim, she's got to get over it.
Thank you, Mr.
Thank you, Your
Sanford.
Honor.
Mr. Avely?
May it please the Court. This is a case in which the newspaper reporter knowingly fabricated a specific historical incident that did not take place and knowingly fabricated a quotation that Judge Murphy had not uttered. No one told Mr. Wedge that Judge Murphy had said, "Tell her to get over it." Crowley testified he didn't know where that came from, and moreover, he testified that if Wedge had said that to him, he would have corrected him. Even Wedge said that he might have been told, "She's got to get on with her life and get over it." The only one who says that that's what Crowley told Wedge is Fitzgerald, and the jury was perfectly well entitled not to believe Fitzgerald. Fitzgerald, a former reporter, his daughter worked at the Herald. He started out with the editor of the Herald. He's a very good friend of the editor of the Herald. He goes to their Christmas parties. He goes to their retirement parties. The jury could have easily rejected his testimony in favor of Crowley and Wedge's testimony. No one told Mr. Wedge that prosecutors confronted Judge Murphy in his chambers. Wedge said that he was unable to say whether that was true. He was unable to say whether it was even consistent with what his sources had told him. Crowley testified that Judge Murphy's remarks at all times were conversational, not confrontational. Fitzgerald and Walsh both testified that they never told Wedge that
Mr.
prosecutors
Avery, let me
had
ask you
confronted
the
him.
same series of questions that I asked Mr. Sanford. Looking at damage awards in libel cases from juries that have been upheld on appeal, given that we, and I'm sure and I know you recognize, that what we are doing here is very different from what an appellate court usually does on fact-finding. And as a general matter, we don't look again. We really don't look again, correct?
I understand that, Your Honor.
So we now are in a very different playing field. And when you look at, for public officials, the libel awards that have been upheld, I have found very, very, very few involving public officials, other than, directors of athletics who happen to be at a state university, and judges in particular. So what is
I agree with you.
So what is your best case that says this is what we should do? I recognize that there are errors that the defendants have conceded. There were errors in the New York Times advertisement against Dr. Martin Luther King. There were errors about what they sang. There were errors about how many times he'd been arrested. So the fact that there are a series of factual errors for these purposes doesn't get you.
There are, Chief Justice Marshall, more than errors here. The words "get over it," in and of themselves, have no gist. They have no meaning.
Of course
they have
they
no
do.
tone
Of
of
course
voice.
they do.
No, it all depends on the context. If one says we should get this young woman some counseling so that she can hopefully get over it,
No, you
that's
just
one
said to me,
thing.
get over it doesn't have. Get over it is a very loaded term.
Well, it depends whether you're saying to
Well,
someone.
put it this way. Let us assume that Mr. Crowley did not tell Mr. Wedge, or that nobody told Mr. Wedge all about she should have some counseling. All he said was, in talking about a victim, he said, get over it.
It still depends, Your Honor, on whether he says, tell her to get over it. I hope she can get over it. It all
If
depends
it's
on
just
the context.
get over it. It's not, I told her to go to counseling. I mean,
Crowley himself testified
right.
that he might have said to Wedge, she has to get over it, which is consistent with what everybody who attended the McSweeney lobby conference said that Judge Murphy had said. The Herald wrote a story which painted a picture of prosecutors marching into Judge Murphy's chambers to confront him about his sentencing practices. That did not happen. They said that he heartlessly demeaned victims. That did not happen. They said that he said, tell her to get over it. That did not happen.
Well,
They painted it in the worst.
Take a look at it from a different point of view. And again, this is not a credibility statement. This is simply looking at it from a prosecutor's point of view. If somebody says, in connection with age, for example, I don't care how old she is. I don't care if she's 75 or 85 or 110. If you're the prosecutor who is trying to make an argument to a judge that it does make a difference because presumably with age comes frailty and the fact that you attack somebody, that can be viewed as heartlessness, which means the following. It is possible that statements that the judge did not intend as heartless were viewed as heartless, which means that when the reporter, when the prosecutor reporting this, is reporting it to a news person as a heartless statement.
But no one said they told Mr. Wedge that he had said anything heartless. No one said they told Mr. Wedge that Judge Murphy had demeaned victims. No one told Mr. Wedge that Judge Murphy had derided the victim, chastised the victim, which are words that the Herald used in some of the stories that were found libelous.
More importantly, wasn't there testimony by a clerk magistrate who apparently was there that said Judge Murphy said that the victim, and I quote now, should be in counseling to help her cope with her situation and to help her put the matter behind her so she could get on with her life?
Yes.
Now, if the jury accepts that, which they have every right to do, that directly contradicts what got into the newspaper, puts a completely different context on the whole episode, with which I agree with you on.
Was there an attempt by the reporter to ask the clerk magistrate what had happened?
The reporter did not interview anybody except the three prosecutors. He did not talk to any of the other
No,
participants.
wait a minute. He attempted to interview the judge.
Yes, and
Correct, on 2 occasions.
well, by the way, the jury didn't believe that. The jury didn't believe that he had attempted to interview the judge on the first occasion.
didn't.
The
And
jury,
is it really an interview
the
to
jury
stop
found
someone on
the
the
jury
street?
found that that was libelous, and Judge Johnson then overturned it
And wasn't the-
because he said declining comment isn't defamatory.
Wasn't the
but
clerk
the jury didn't believe
wasn't
that.
the clerk magistrate there when the comments were made?
Yes.
In which case?
McSweeney.
In both cases. The first lobby conference was attended by the clerk, the probation officer, 2 defense lawyers, and David Frank. The Wedge didn't interview any of those. The second lobby conference was attended by 2 defense lawyers, Mr. Crowley, the clerk, and again the probation officer, and the only person that Mr. Wedge interviewed was the prosecutor.
Recipient witness, the clerk, who was there, who testified, who gave the testimony that I just recited, who wasn't even interviewed, who may, and the jury could have accepted his testimony. And you've got all these other statements that you're talking about. She tearfully testified, all that, in which it's admitted there are no sources, correct?
Correct.
This seems pretty bad to me.
This is not a case where we're asking the reviewing court to draw every conceivable inference in Judge Murphy's favor or to comb the record to find something to support the jury verdict.
That's not the standard.
This is overwhelming evidence in this case. Undisputed facts, statements by Mr. Wedge, statements by Mr. Crowley, that the confrontation, the angry judge lashing out at a poor 14-year-old rape victim, tell her to get over it, that never happened.
What about the
Never
destruction
happened.
of the notes? Couldn't the jury draw a negative inference from that?
I think the destruction of the notes is very significant because it did come after Owen Todd, a former judge of the Superior Court, had told David Wedge, Judge Murphy didn't say these things. You have misquoted him.
How do we evaluate Owen Todd's testimony in contrast to the testimony of Wedge on that particular issue in our function to review the evidence?
All the courts have said that credibility determinations remain with the jury.
But we don't know exactly which statements they believed and didn't believe. I mean, they could disbelieve that and still come to the conclusion that they did.
Yes, that's true.
So
and
that doesn't really help us.
There's an interesting.
Do we take inferences? Do we take inferences in the light most favorable to the plaintiff?
Well, I was about to say there's an interesting byplay between Justice Stevens and Justice Scalia about this in the Supreme Court, in which Justice Scalia, joined by Kennedy, Chief Justice Rehnquist, and Justice White, say that you find all the inferences that the jury could have found in favor of the plaintiff, that those are the ones you accept. Justice Stevens says, on the other hand, you take the inferences that the jury must have found in his favor. And the Supreme Court hasn't really resolved that question. But it seems from the evidence that it is highly likely that the jury accepted Owen Todd's version of this matter instead of Mr.
Mr.
Wedge's.
Avery, did Mr. Todd at that time, immediately after the first article appeared, I take it that what he said was consistent with Judge Murphy's statement, not that I told her about counseling to get over, but just that he never made that statement.
Correct.
So what is the evidence that, well, I take it that Judge Murphy says the words "get over it" were said.
Not in the Burgess and Freights lobby conference.
I understand that.
In the first lobby conference,
I understand that.
They were said in the context of, can't we get her some counseling so that she can get over it? Everybody who attended the Burgess and Freight conference, except for Crowley, says that those words were not said there, and the topic of the rape case never came up there.
Was there evidence that Crowley had spoken to any other prosecutor before the second lobby conference at issue here about what had happened in the McSweeney lobby conference?
There was no direct evidence on that point.
Okay.
What there was evidence of was that this district attorney's office had been in the newspaper criticizing this judge for quite some time, and there was a buzz about it in the prosecutor's office. There was a scoreboard in the prosecutor's office where they kept track of Judge Murphy's rulings. And on that point, I want to make one very important point, Chief Justice Marshall, which is that this jury was extremely discerning in its treatment of the evidence in this case. It did not return a verdict of libel with regard to any of the statements that were general criticisms of the judge's sentencing practices, his bail practices.
And we know that
the
because
sort.
of the special verdict form?
We know that because of the special verdict form.
Okay.
It's at tab 30 in the appendix. There were 61 statements. They found 22 of them libelous. The ones that they did not find libelous were the sort of general criticism that it's very important to protect from a First Amendment point of view. And I would also point out that Judge Murphy didn't sue the Stanford Times. He didn't sue the Boston Globe. He didn't sue any of the reporters or newspapers who were criticizing him for decisions he made on the bench about sentencing or about bail. He sued David Wedge in the Herald because they completely made up a vicious attack by this judge against a helpless victim.
I have a
Mr.
procedural
Avery, you
question.
know, of course, that what happens in the wake of a publication makes a difference, and that is why I'm probing you as to what was told to the Herald, not what was told to the Herald's competitor across town.
Well, Owen Todd spoke directly to
No,
the
I
Herald.
understand that. And the testimony was he said Judge Murphy did not make that statement, or this is what the statement was.
The testimony was Judge Murphy did not say that. You have misquoted him.
But he did not say, this is what Judge Murphy said.
No, he did not.
So that the reporter is left with a view that says, I have got 3 people who say, including one percipient witness, who says, this is what was said, and then 2 witnesses to whom that person reported. And you've got another person denying.
There's a little bit more than that.
Okay.
And that goes to another basis on which the jury could have found actual malice here, which is that this district attorney, Walsh, had told Wedge, I'm mounting a media campaign against this judge. I intend to fire a shot across his bow. So that Wedge knew not only that he was dealing with biased witnesses, this isn't an ordinary biased witnesses case. This is a case in which Wedge knew he was dealing with people who had a media agenda that they intended to use him to put in
That
place.
is consistent with what the First Amendment protects all of the time. So the fact that somebody has a media agenda, I don't think ever, Mr. Avery, has been held a basis for actual malice. In fact, if that were the basis, we would be upholding libel awards, because there's almost invariably, especially for public officials, a real agenda.
And that's why the reporter has to do a little diligence in order to make sure that what he's reporting is true.
Sure,
That
I
he
mean,
can't just rely on the
You have
DA.
to look at it in the context. I mean, I agree with the general principle that was just expressed, but if the reporter is getting this information in the context you're talking about, that a district attorney is out to get this judge, to use the same verb that got this reporter in trouble, he's got to be thinking critically. I've got a biased source here.
And that's why you go to the person against whom the bias is directed and ask the person to respond.
But if that person's a judge, he may not feel free to respond, and in any event, the response is going to be treated with the same contempt that Mr. Sanford
We don't
treated
know
it
that.
here, that it's just a denial. He should have gone to the other people who were present.
Well, he certainly couldn't have gone to a clerk magistrate. I mean, if the judge can't talk, a clerk magistrate. By the way, one
He
of the
could have gone to the defense lawyers. Their names were given to him. He could have gone to the probation officer.
Well,
Her name was...
I'm not so sure about the probation officer, the defense attorney. Judge Murphy, I think I saw somewhere, took the position that it is, I think the word was a rule that you don't repeat outside a lobby conference what is said in a lobby conference.
There was some testimony
Of
to
course,
that.
we've had case after case that has said that lobby conferences should be recorded and there should not be unrecorded lobby conferences. And if this lobby conference had been recorded, we wouldn't be here today. And so clearly what is said in lobby conferences is publicly reported because it then becomes part of the transcript.
I understand that.
Did Mr. Wedge contact the defense attorneys who were present?
No. Made no effort to contact them.
Okay.
And
I have a procedural question. I'm just a little confused. Maybe you can help me. The trial judge's memo talks about 50B and 59A motions, but the briefs talk, at least the defense's brief talks about a 60B motion.
He made ordinary new trial motions under the ordinary new trial and JNOV rules.
Okay.
But 10 months later, he made a 60B motion raising the subject of these letters, which he had not included
Right,
in
but
his
the
original
judge's memo
motions.
is directed to the 50B and 59A motion.
Correct.
That's what it says.
That's correct, although he did, and then there's a portion of the transcript in the addendum of my opponent's brief referring to the disposition of the 60B motion. I see the red light is on. I'd just like to say one thing in conclusion.
Well, I
which is-
certainly gave Mr. Sanford time, so you may have a...
Thank you. Which is that, of course, we appreciate that it's necessary to have a robust debate about how judges conduct themselves on the bench. But it's also important, and particularly important now, that we protect the independence of the judiciary. You mentioned Texas. The vast, vast majority of the judges in this country are elected. It's fair enough for the public to debate and the newspapers to debate how they conduct themselves on the bench. But it is a serious blow to the independence of the judiciary if a reporter can completely fabricate a story and print that, and there's no opportunity for the judge to get justice from our justice system. Thank you very much.
Thank you, Mr. Avery.